afternoon, everybody. We're going to go ahead and get started here in 1 minute. I just wanted to do a quick sound check. If you can hear me, please put a yes in the question section. Thank you, thank you, thank you. Emily, go ahead and say something, please.
Can you hear me?
I can hear you. Everybody, can we hear Emily as well? Awesome. Thank you, everybody. So it is officially 12:10. We're going to go ahead and get started. My name, of course, is Thad Graham. I am the education specialist with the Victim Services Program. Today we have a very special guest with us, Emily. Emily, go ahead and introduce yourself, please.
Hi, everyone. I'm Emily Freed. I'm the staff attorney at the FSI Justice Project. We are associated with the Family Services, Victim Services Department, and I'm happy to be here to talk about litigation abuse.
Awesome. Thank you, Emily. Emily is going to provide some firsthand experience and some further insight into litigation abuse for us. Emily, thank you so much for being here. We are very, very lucky to have you here. So, of course, today we are going to be talking about the courtroom as a weapon, litigation abuse. As always, our mission here at Family Services is to provide resources to build healthier relationships and promote personal growth. Our vision is to engage with the communities to meet the needs of their most vulnerable members. Of course, a trigger warning, we are going to be talking about domestic violence and tools used by abusers to continue that abuse on their victims. So as always, please make sure you take your mental health into consideration first, as always. So today's objectives are simple. We are going to define domestic violence and its synonyms. We are going to define litigation abuse. We are going to discuss common forms of litigation abuse and discuss what can be done to combat litigation abuse. And of course, as always, we're going to open up at the end for any questions that you may have for myself or for Emily, probably more importantly, Emily. So what is domestic violence? Domestic violence is defined as a pattern of coercive behavior used by one person to gain power and or control over another individual in an intimate or familial relationship. Remember, we often think of domestic violence as just dealing with, boyfriend, girlfriend, husband, wife, that intimate relationship. But it is not just that. It can deal with any familial or intimate relationship. Many terms are going to be used interchangeably to describe and discuss domestic violence. It may be referred to as abuse, domestic violence, battery, domestic battery, intimate partner violence or IPV, DV, family, spousal, relationship, or dating violence. If we're talking about younger people, we could be talking about teen dating violence or TDV. Any of these terms can be used interchangeably, but we're talking about the same thing. We're talking about using coercive behaviors and a pattern of coercive behaviors to gain power and or control over another individual. According to the CDC, 1 in 4 women and 1 in 7 men have experienced physical abuse from an intimate partner. Remember, though, it is important that domestic violence is not just physical abuse. We often think of domestic violence as that black eye. It's that person that, female, most likely, who has a black eye, a broken, and bloody lip. But domestic violence is so much more than that. It can be characterized by many types of abuse. All or any of these types of violence and abuse may occur in a domestic violence situation. Those include emotional abuse, physical violence, stalking, sexual violence, financial abuse, and verbal abuse. Today, we're going to be looking at litigation abuse, which is a form of both emotional abuse, financial abuse in some instances, and also a form of stalking. It's stalking while using the court system. Whenever we talk about domestic violence, we of course have to refer back to the power and control wheel. This outlines what domestic violence looks like for most individuals. As you can see, no matter what we are talking about, whether we're talking about using coercion and threats, intimidation, isolating the victim, using their children against them, we are talking about the use of power and control. Someone gaining power or control over another individual. Once again, it doesn't just have to be for, older adults. Abuse can occur in the teen relationship. Often this is overlooked, especially by parents. It is considered not a big deal. Unfortunately, teen dating violence is a big deal. It's something that we have to be aware of, and we have to consider it to be, a real worthwhile offense. It's something that we shouldn't just put off as no big deal. Lastly, LGBTQ+, we often think of a domestic violence relationship as a male abuser and a female victim. But domestic violence and intimate partner violence can affect anybody, no matter what the relationship. It doesn't just have to be, what we think of as that cisgendered male-female relationship. A female can be the abuser. A male can be the abuser. A male can abuse another male. A female can abuse another female. It doesn't matter the relationship status. It just has to deal with someone wanting to hold and exert power or control over another individual. So now that we have defined domestic violence, we're going to get into litigation abuse, a form of domestic violence where the courtroom is used as a weapon. So litigation abuse is defined when someone uses the legal system to take power and control over you or another individual. Litigation abuse can also be considered or called abusive litigation, legal bullying, vexatious litigation, paper abuse, separation abuse, and like I mentioned earlier, stalking by way of the courts or stalking by way of the legal system. Emily, feel free to add anything at any time when it comes to litigation abuse. Got me?
I got it. Thank you, Thad.
Hey, you're welcome. So litigation abuse. Abusers will use any available means and the civil court system to exert power and reestablish control over survivors long after the relationship has ended. One of the things we have to remember when looking at domestic violence is that when an abuse victim decides to leave, that is when they are the most vulnerable. That is when the abuser is losing power and or control over the individual. This is when it is the most dangerous for that abuse victim, for that survivor. Once they have finally left, which can take up to 11 times, it's not something that's going to happen automatically. It's going to take time. It's going to take several attempts for them to leave. Even after they have left, an abuser can use the court system to continue to exert power and try to reestablish control over that survivor. Unfortunately, family law cases typically last a long time. They can be reopened very easily, and they become the perfect opportunity for abusers to repeatedly force survivors back into court. It forces the survivor to come face to face with that abuser again and again. And it can be done no matter what. Even if the abuser is in prison, they can file and can once again exert control over this individual, even from prison. Even if you have left the abuser, he or she can cause psychological, emotional, and financial harm by taking you or even your friends or relatives to court again and again. Remember, it is a tool to exert power and control even after this survivor has left. Abusers are able to misuse the court proceedings in order to control, harass, intimidate, coerce, and or impoverish the abused partner. The legal system unwittingly becomes another avenue that abusers can exploit to cause harm and financial devastation. Litigation abuse is a particularly manipulative method of domestic violence because it weaponizes the judicial process against the survivors. These survivors have to trust that the legal system will provide protection. They have to trust that the legal system will provide them with protection and answers that they're looking for. Unfortunately, it can result in survivors losing trust in the courts and deter survivors from exercising their rights to access the justice system. Abusers using manipulative litigation can cause these survivors to lose their resolve and to lose their belief that the court system will get it right. Abusers will intentionally and excessively file frivolous lawsuits and motions to force contact with survivors who are compelled to return to court and face their abusers. Most common abusive litigation tactic is to deliberately run up legal expenses by filing frivolous requests and demanding excessive or irrelevant information in the discovery process in hopes of leaving the survivor without representation. Emily, have you seen this used against you and your people as well?
Thad, I see this almost on a daily basis with my clients. I serve domestic violence survivors for free in civil legal representation matters, so family law, meaning divorce and custody and child support matters. And this happens all too frequently because if you think about it, the only time these parties would ever be in a courtroom is after the survivor has left the abuser. That's the only time they would be in litigation. And at that point, the abuser has lost their ability to control and have power over the survivor. So the only way left to control them is through the children or through divorce proceedings and their property. And sometimes these abusers view children as their property. So the problem is you can't prevent somebody to have access to the criminal justice system, the family law system. So abusers take serious advantage of this. They, as you said, they weaponize the judicial system where they file excessive petitions. They'll file these petitions and then they won't appear in court, leaving our clients having taken whole days off of work because they were subpoenaed to be there for a hearing that the abuser didn't even show up to. We've even had instances where an abuser will file petitions for contempt or special relief in custody, and the night before the hearing, our client's tires will have been slashed, so she couldn't make it to the court hearing. So we see this constantly, and it's, as you said before, there's reasons why survivors don't leave abusive relationships, and a lot of the time it has to do with the threats these abusers will make, saying, if you leave me, I will take you and I will take these children from you. And if you think about it, every other time an abuser has threatened a survivor, most of the time those threats have come true to them. So they really are afraid that if they leave their abuser, their children will be taken from them. And unfortunately, a lot of the time that does happen in Blair County. Domestic violence is not an easy subject matter to present to the bench, meaning the judges in Blair County. It's not an easy thing to present and try to prove because it's usually viewed as a he said, she said thing.
Gotcha. Now, I have another question here for you when it comes to the financial burden. Does that financial burden fall upon the abused victim if they aren't getting free civil representation from like family services?
Oh, sure. I mean, if they want to, I mean, if they attend the court hearing by themselves without an attorney, most likely they'll have had to take days off work and they'll lose whatever financial income they could have had from that. Or if they have to hire an attorney, a local attorney to represent them. I mean, most attorneys that I'm aware of in this county don't charge per hearing. They usually require retainers for them to appear on behalf of the client, and that could be up to thousands of dollars. So it's very difficult for a survivor to combat litigation abuse, and these abusers know it. And so sometimes we've even seen our clients have just given up, where they have agreed to just give over their custodial rights of their children to the abuser because they cannot take the litigation abuse anymore.
Gotcha. That's sad.
It's really sad. It's really sad.
Okay. So, you've already said this. Many attorneys cannot continue to represent a survivor when faced with constant motions and court appearances, particularly if the survivor is not able to pay for the ongoing litigation. Survivors are compelled to make concessions in family law cases out of fear of navigating the complex legal system on their own, giving up demands for children or spousal support, and giving in to less desirable resolutions. Does this happen in Blair County, where attorneys will stop representing a client because of litigation abuse, where they are just being constantly taken to court over and over again?
Well, I don't believe that particular scenario happens, because once you enter your appearance as an attorney on behalf of a client, you have an ethical duty to remain involved in that case without a order from a judge allowing you out of that case. And sometimes I've seen that happen, where if a client is depleted of their income or their finances and they can't afford an attorney anymore, an attorney can go to court and ask the court to allow them to withdraw as counsel. And most of the time, if it's a financial burden for the attorney to continue representation, the courts will let attorneys out, because, I mean, let's face it, attorneys need to make money too, and I think the judges are sympathetic to that. But I can tell you that from my experience, I'm dealing with a matter right now where the abuser is self-represented, and he consistently emails me on a regular basis trying to make it seem as if my client is really the abusive one, and that their child is a victim of our client. And I believe that if this information were presented to an attorney that didn't have my education and experience regarding domestic violence, that they might start to believe the things that are being said about their own client. And then at that point, an attorney might withdraw as a ethical matter, saying that they could no longer represent an abuser themselves. However, I am very well aware of these tactics that these abusers employ, and I believe that he's just trying to do that to make me want to withdraw.
So I know we're going to talk about this later, but is a way to combat this then to further educate attorneys in Blair County to litigation abuse and to tactics of domestic violence and abusers?
That would be ideal, but yeah, that would be ideal.
Gotcha. So we have some common forms of litigation abuse, and you've talked about a bunch of these. Anything from starting a custody battle to filing for protection orders against you and or your family or friends, filing contempt motions against you for no reason, describing you as an unfit parent or requesting mental health evaluations, filing unnecessary or frivolous motions, appeals, motions for revision, or motions for reconsideration, forcing you back into court again and again, trying to bring closed cases back into court, and trying to relitigate in different courts or switching jurisdictions. Anything you would like to add on any of these before we go on to the next ones?
I could just add to that, Thad, that one thing we see a lot of that might not be recognized as litigation abuse, but I see it as such, is frequent calls to Blair County Children, Family, and Youth by saying that, mother is doing X and you need to go out and investigate because my child's being abused. And in fact, we just recently had a case where our client had, in 6 months, 17 calls to CYF from her abuser about her parenting skills, to the point where she's terrified to even be a parent, enjoy being a parent. So I would consider the frequent contact to CYF, and unfortunately it's anonymous, but based on the allegations to CYF, we know who is making the calls. It's always father and his family. I think CYF is pretty good, at least our CYF in Blair County is pretty good at deciphering the truth of the matter. I mean, usually these caseworkers show up to my client's home and they're like, "We're here again. I see your child is fine. I see your home is fine. Sorry to bother you." It's just, it gets to be too much. And I really think that is a very typical tactic that I don't think the court system sees as litigation abuse, but I certainly see it as litigation abuse.
Emily, you doubt me. Actually, I do have this on that list as well, because I didn't see it originally, but I thought that it could be something that could be considered. So some other common forms: using the court's discovery requests or using the discovery process to bring up embarrassing or irrelevant information, dragging out court hearings, harming you financially or emotionally, refusing to obey court orders, forcing you to spend time and money to enforce the orders, threatening to report you to immigration authorities. When it comes to refusing to obey court orders, do you see that abusers often do not obey court orders when it comes down to custody or other agreements, including PFAs or CPOs?
All the time. This is all the time that happens. And frequently, I can think of a few cases that I've handled where the abuser will flat out refuse visitation, court-ordered visitation with his children, and then turn around and then file a petition for contempt saying that mother denied the visitation when in fact he refused it in the first place.
Thank you.
Yeah.
So I got you right here. Making false reports to Child Protective Services, CPS, or Children, Youth, and Family in Blair County. Falsely claiming you abuse drugs or alcohol. Suing you for reporting abuse. Filing complaints against the judge or your lawyer. And suing or threatening to sue anyone who helps you, including family, friends, advocates, attorneys, and law enforcement officers. Emily, have you had complaints filed against you
Yes.
by abusers?
Yes, several times. They make complaints to the disciplinary board, which maintains my law license, but nothing has ever come from it. In fact, I am currently being sued federally by an abuser for, I can't even decipher why he's suing me, but it's just another tactic that these abusers employ once they feel like they have lost their power and control over the survivor.
Now, for example, being sued federally, for another attorney that's maybe practicing in a private law setting, is that something that would deter them or maybe have them withdraw themselves from a case?
Possibly, depending on the lawyer. Some attorneys might think that I don't have time for this, like this is my law, this is my life, I can't afford this. However, as an attorney, we carry malpractice insurance, so that would allow them to have representation to defend them in their lawsuit. But yeah, some attorneys might be so busy and think, I don't have time for this, I can't have you as a client anymore, and they might file that petition to withdraw as counsel.
Thank you. Okay, Emily, so the last question I have here for you is, what can we do to limit or even stop litigation abuse? What can be done to help these survivors, help these victims, and to stop weaponizing the court system?
Yeah, so like I said before, unfortunately, there is nothing that can be done to prevent somebody having access to the court system or to CYF. So what we can do is, I've done it in other cases where I have filed petitions with the court in Blair County asking that the abuser has to ask permission before they can file a certain petition. So I was having this frequently happen where an abuser would file a petition for contempt or special relief in custody, and then he would just not show up, knowing that our client would show up, I would show up, and everybody would waste their time, and he wouldn't even come to defend his petitions. So the court granted our request that from now on he had to petition permission before he could file anything in court, which means me as the attorney would have to go to court with him, and our client wouldn't have to attend. And he'd have to lay out on the record why he wanted to file a certain petition before he could actually file it. So that's one way we can do it. I have requested the judge order sanctions and counsel fees for the excessive frivolous filings filed by abusers. I can say I've not been successful in requesting sanctions and counsel fees in abusive litigation cases, but that doesn't mean I stop trying. Another thing that's we could possibly do is order that the parties have to communicate by certain apps that don't allow for the deletion of messages. So for instance, that abuser that I told you, he would refuse visitation and then file contempt saying our client denied it. I would provide screenshot text messages, print off the screenshots and attach them as exhibits to my petitions, but so would he. He would manipulate text messages to make it seem as if our client said, no, you can't see these kids, I hate you, you're never gonna see these kids again. So he would, it's amazing what these abusers are capable of, but he would create a false conversation and make it appear as if my client had that conversation with him when he didn't, and when she didn't, and he'd attach it, and so the judge didn't know who to believe. So one thing we can do to try to prevent that is, in cases like this, order that the parties use a third-party app called, like the Our Family Wizard app is one of my favorites. Talking Parents app is another one. Some of these apps require a fee, a yearly or monthly service fee, but since all of my clients are indigent and receive free legal representation, those apps waive whatever fee that is associated with their use. One thing that I'm hopeful about for in the next year in 2022, with the retirement of Judge Milliron, the judges are now going to have just 2 judges in Blair County that handle custody matters. And that's going to be Judge Jackie Bernard and Judge Wade Kagerice. They're the only judges that are going to hear custody matters in Blair County. So for instance, right now, all 5 judges on the bench handle custody court. And sometimes it gets confusing when all 5 judges have issued orders in the same case. They don't remember the faces, they don't remember the parties, and they can't recognize that, okay, this guy has filed 15 petitions in the past month. Like, this guy, something needs to be done about this. This is frivolous litigation abuse, and we need to do something about it. So I'm hopeful that with the judges now being assigned, the 2 judges being assigned to custody court, they'll start to recognize signs of abusive litigation.
Awesome. Now, I know you said about fees basically for filing, that some states have taken up an approach like that to limit litigation abuse. Other states have moved with the ability for the victim and her counsel to actually file litigation abuse claims that are then investigated by the court. Is that something that can happen in Pennsylvania, in Blair County?
I mean, that would be wonderful if possible. However, I just think sometimes if you just put the thought in a judge's head that the potential for the abuse is out there, and that a judge will be personally offended, I think, if they think that their time is being wasted and they are being used as a pawn by an abuser in this abusive litigation tactics. I think then if once you put that thought in their head that, okay, judge, you're being used here, this man is seriously abusing the judicial system and wasting everybody's time here, I think then they'll start to take a closer look at it. So, and whenever I feel like I am involved in an abusive litigation case, I always put that in my petitions that this is abusive litigation. I define it. And I even attach scholarly articles to my petition so the court can reference it so they are aware of it. So anytime I can get the judge's attention that this might be an abusive litigation case, I will bring it to their attention. So as whether or not this could be something that happens in Blair County, what you just mentioned, maybe someday.
Awesome, awesome. Well, one last thing, Emily. Tell us just a little bit more about the FSI Justice Project, if you would like, and kind of, what you do over there. It's something that doesn't get talked about very often, unfortunately.
Yeah, so we are a law office that's funded by the Pennsylvania Coalition Against Domestic Violence to operate. I am the only staff attorney there. Joel Seeley, who is a partner in his own law practice here in Blair County, Grable and Seeley, he is the senior managing attorney for our program. We also have one other staff member, Lisa, is my assistant. So we run on minimum manpower over there. We receive referrals for clients only through that number you see on that screen, that 814-944-3585. That's if you call or know somebody that needs civil legal representation in family law matters, they would call that number and get family services hotline or helpline number, and they would put you in touch with an advocate who would then refer you to my office. We do not advertise my law office phone number or our address for our client safety and our staff safety. But we don't just do family law cases. I can help in mortgage foreclosure, PFAs, things like that. Whatever if you're listening and you think someone could possibly use our services, please don't hesitate to have them call that number and we can figure out a way to help them.
Awesome. Thank you. Thank you very much, Emily. And thank you for your time. And, Lisa, your do-it-all assistant, the awesomeness of Lisa as well. You guys do an amazing job over there at the FSI Justice Project. Like Emily said, if you have, any questions, if you feel like yourself or a client or someone could use those legal services and legal representation of Emily, you can call our helpline, 814-944-3585, talk to an advocate, and those advocates can answer any questions that you may have and hopefully make a referral over to Emily and Lisa.
Yeah, and if I wanted to just add to that, I'm sorry to interrupt.
Yeah. You're fine.
If anybody knows somebody that is interested in leaving a abusive relationship, they can always be sent as a referral to my office just so I can explain to them their options. Nobody would pressure them to actually leave the relationship. Nobody would pressure them to file divorce paperwork or custody paperwork or anything like that. We just simply would like to safety plan with them and discuss their options and going forward when they feel ready to leave the abusive relationship.
Hey, I didn't know that, so I learn new things every day as well. That's awesome. You can find the rest of family services, including the Victim Services Program, on social media. You will not find FSI Justice Project on social media, but like Emily and I have both said, if you would like more information on them, please reach out to the Victim Services Program on our helpline, 814-944-3585. You can call or text that number 24 hours a day, 7 days a week. It is a free service. Once again, any of our webinars can be found on our Go To stage and also on YouTube. Family services information as well. And don't forget, Webinar Wednesday still has 2 more weeks remaining. Next week, we are going to look at why abuse victims stay and try to dispel some of the myths when it comes to domestic violence. And lastly, we're going to be helping our heroes, domestic violence in the veteran population. I saw Rashonda on here from the VA. We are actually going to have some experts from the VA, the James E. Van Zant Medical Center, helping us with that webinar as well. So please, we hope to see you over the next few weeks. Remember, Women Aware is back. It is a free educational support group for women who have experienced domestic abuse in their intimate relationships. If you have questions or know someone that could use this service, please call our helpline, 814-944-3585. Any questions for myself, most likely Emily, but if you have any questions, please put them in the question section now. If not, we of course will see you on our next webinar Wednesday. Emily and I will hang out for a few minutes in case any questions come up. If not, everybody have a great day. Okay, I'm not seeing any questions popping up for Emily. So, Emily, thank you very much for your time.
Yeah,
It was truly a pleasure. And
definitely.
I'm going to go ahead and end this. Thank you again. And thank Lisa as well.
All right. Thank you, Thad.
Hey, thank you. If you have any questions for Emily, please feel free to send me an email. My information, of course, is always on screen. I will be happy to forward those questions to Emily and have any of your questions answered for you. Thank you all for your time.